Welcome back to the morning show here on Arise News. President Bola Tinubu's one-year anniversary as President of Nigeria, he continues to battle a weakening economy and an unending insecurity which threatens progress made in Nigeria's democratic development of uninterrupted 25 years of democracy. Amid the high cost of living and deepening distrust in government policies, Tinubu's administration has significant work to do in improving national, state, and local security and governance. As the present government continues to do its best in ensuring food continues to be on the table of Nigerian workers, amid the minimum wage face-off between organized labor and the federal government, more efforts must be directed in ensuring that farmers' inability to access their farms due to attacks by bandits becomes a thing of the past. Joining us now on the morning show as we look at the state of the nation amid food insecurity and political face-off is Aondoakaa, a senior advocate of Nigeria and former Attorney General of the Federation and Minister of Justice. Good morning, Mr. Aondoakaa. Thank you very much for joining us on the morning show.
Good morning, Mr. Dr. Ruben.
Yes, morning. Thank you for joining us, sir.
I say yes, good morning.
Good morning. Thank you for joining us. Well, quickly, your take on the state of the nation, 25 years after return to civilian rule and 1 year of President Bola Tinubu in the saddle. Will you give the government a pass mark? Will you say democracy has served us well?
Well, first I will give pass mark to the electorate who has kept faith in ensuring that democracy strive up to 25 years in spite of the extreme conditions we found ourselves. I'll also give a pass mark to President Ahmed Bola Tinubu, particularly in the area he's trying to make sure that the local governments that are the third tier of government remain independent and functional. Let me thank my successor, Fagbemi SN, who has taken the bull on the horn, because during our time we tried to legislate and give the local government an autonomy. Unfortunately, it did not survive in the Supreme Court and it was struck down. But you see, the federal government, state government, and the local governments must keep to the boundaries as enshrined in the Constitution. I don't think the federal government is choking the states, but it does appear that the states are choking the local government. And the local government, which is the third tier of government, closer to the people, is not functioning. And that is where the problem is. The government that is very close to the people, the basic needs of people, relating to security, relating to rural infrastructure, like rural roads for agriculture, is not functioning. And I think the step taken by the president now, by going to court, is commendable. And I believe we had a crossroad before, and the Supreme Court are also judges that live in Nigeria. We had a situation similar to what is going on in the local government. We had a case, Savannah Bank versus Ejiro. That time, it has to do with a constitutional provision that requires government consent for borrowing money in the bank, in respect of legal mortgage. If you borrow, no matter the amount of money the government gives, the bank gives you, if eventually the bank cannot get the governor's consent, the Savannah Bank as a juror said you cannot recover. It's an illegal contract. But as it went on, the Supreme Court in some wisdom saw the reality of the economic situation, the reality of the fact that banks were losing money, and reversed it and heard that in spite of the fact that governor's consent for legal mortgage is statutory, equitable remedy can be given to the banks to recover their money. So I'm hoping strongly that the case now for local government autonomy pending in the Supreme Court the learned justices, without prejudicing the case, we have a second look. Thank you.
All right, thank you very much, sir. And just in terms of the state of the nation and just reviewing, chief of this would be the security architecture and the security situation or insecurity in the nation. How would you assess this administration's handling or managing of insecurity in Nigeria? What should be done, what ought to be done in terms, especially in the Middle Belt area, where unfortunately we've still seen spates of violence, attacks in that area, even though we had hoped that it would be contained, at least in the first few months of this administration. What's your assessment of the situation on ground?
Well, the situation is not much encouraging. First, the issue of situation, especially in the middle, but where we produce a lot of food, and generally in Nigeria, where like Ikita and other places where food stuff, which are basically agricultural state, the situation is the root cause of the hunger that is now the main issue facing the nation. The main issue facing the nation may be classified majorly into two. The issue of hunger, and the issue of security, and those of them are tied together. If you understand, our people, especially, I'm a thief man, we don't beg, and most part of the country, the farmers do not beg. They produce their food, which they eat for breakfast, lunch, and dinner. But if you go to rural areas now, the insecurity has been so intense that the farmers can't go to farm. And they are coming to compete with the middle class people in town by buying indomie, as much as ridiculous are coming to buy indomie to feed their children. That is the challenge. And if the security is tackled, 50% of the hunger in the country will be reduced. Because our farmers will go back to farm, they will produce for subsistence. Even they used to produce for subsistence and also sell the surplus. Now, even production for subsistence is becoming impossible. You can't access your farm. Go to my state, you can't access the farm. The herders have taken over the farmlands, and they're extremely brutal. The farmers cannot go to even farm ordinary cassava that we used to cook in the morning to eat with Beneseed. This is the challenge, and this challenge is all over. Apart from the harder situation, you have banditry, kidnapping. All these are things that if the maximum and the constitutional provisions of government is protection of lives and property. And I feel that if the government can't minimize this rising trend of insecurity to the barest minimum, our country will bounce back. Because if you look at it now, specifically on the issue of rice, government decided that, okay, look, let us not import rice. Within a short time, Nigerians are very enterprising. You had over 80 integrated rice mills in the country. You have the smallholder rice mills springing all over the country. And we also made the challenge of supply of paddy. The farmers went to farm, and that created weight for the rural farmers. Suddenly, they can't go to farm. Now there's a gap. The mills are there, but there's no paddy. And then government is now going to go back to the importation of rice, which was costing scarce foreign reserves to the tune of 1 billion annually. That was then. The population of the country has increased. So certainly you are looking at rice importation, which appear to be the most stable food in Nigeria now, to 1.5 billion annually. That is something that if that money is channeled to security, you can be sure that Nigerians will produce their food and even export food. So my plea has always been that the issue of security should not just be the issue of the federal government, it should be the issue of the state and the local government. And that comes to where I say this local government also should be allowed to function. The local governments are not functioning. The state appear to think that security is only for federal government. But that is the wrong perspective. If the state allow the local government that are closer to the people to function fully and set up their security apparatus, and then the state complements, then the federal government that owns the police and other cohesive agencies come in. This issue of banditry can be resolved. We have smaller countries that have resolved it. I've heard from Burkina Faso. The person has been able to take bold steps, have been able to resettle the people who were displaced as a result of insurgents. That can be done in the country. I do wonder, honestly, Dr. Rubin, Nigerian soldiers can go to Liberia and restore democracy within a short, limited time. They can go to Sierra Leone and restore democracy. They are the best in the country outside duties. I wonder really what is happening in the country that Nigerian soldiers, the police, we cannot be able to solve the insurgencies spring out like Northeast and Northwest. I keep wondering what is really going on. So it is something that we must address, and I feel President Ahmed Tinubu should tackle it, call down. If you look at the reality, these are soldiers, professional soldiers that have excelled all over the world. And they have gone in a thick crisis like Liberia, restored peace there. So I believe that this government is going to restore peace. If our armed forces are given the resources, not only giving the resources, the political class that is responsible for their operation, not day-to-day operation, but the political decision must monitor to see the effectiveness of what Nigerian taxpayers' money has been used to curtail the security. But the most important thing is that...
For a breakdown, are you in support of state police then? Because you've talked about bringing it more local and the people who are more in touch with the people. Would you then be in support of state police?
State police is good, but we have to amend a lot of things. First, you have to remove the magistrate from being civil servants. That is the starting point. Amend the constitution, and all judicial officers down to magistrate area codes will be classified as judicial officers, and remove them as civil servants. If you don't remove them as civil servants, the state police, which is desirable at this time, can become a very dangerous weapon, more than an atomic bomb. In the sense that you have a civil servant as a magistrate who is not a civil servant under the control of a governor, and then you have state police. It means an opponent can be arrested on the road, straight to jail. Because the civil servant, the magistrate are not civil servants. They are directly, they are not judicial officers. They are civil servants under the control of the executive. And that is the most dangerous thing. Even though they perform judicial functions, they are not controlled by the judiciary. That aspect should be amended. Of course, some other detailed aspects of the kind of weaponry who imports arms should be, it's something that we need to have a think tank, but it is desirable in the sense that you cannot have a state police and allow 36 states of the Federation importing arms. There must be a window. And I have always thought that the appropriate organ to create and legislate on state police should be the federal government. Remove it, put it on the concurrence list in a sense that federal government will effectively legislate. Because if the federal government legislate, even though the state will have power to legislate, where the laws conflict, that of the federal government will prevail.
Okay.
So I had always thought, and the issue of training and recruitment, these are issues that we have to holistically look at it and be taken care by a legislation that comprehensively lay out the process of recruitment, process of training, process of importation of arms, process of how we can amend the magistrate that have always day-to-day, because a policeman does not work in isolation. As the police arrest, they have to charge the magistrate. And almost most of the offenses are offenses directed to be prosecuted before magistrate and area courts. So if you leave the area courts under the state as civil servant, then the state police that we all desire may be a very dangerous weapon when politics comes. Of course, you have to look at all that. But in the overall, I support the state police, but these are the paid things that we have to look at it.
Okay. So a couple of things. We're still talking about the state of the nation. Number one will be about what I'll tag rights of cow. We saw a debate recently at the National Parliament where some senators vociferously was talking about free movement of cattle when the argument was up for ranching. The right of cow, which dates back to the days of even the cattle route some people have enunciated. That's number one conversation or debate. Secondly, let's also talk about what is happening in Rivers State. Political debacle, judgments and counter judgments, also what is happening in Kano State, the land of two emirs as we speak. The right of cows, debacle in Rivers and Kano.
Where people talking about rights of cows are extremely are talking out of ignorance. There's a provision in the quarantine law, which is on the federal exclusive list. Cows cannot be allowed to move freely, cannot be allowed to move into the country if we are to enforce the quarantine law. I wonder why we're not enforcing it. Because there's a potent danger which is recognized in the Quarantine Act. That if a cow comes into the country, it's supposed to be quarantined and test for disease. There's some infectious disease that if cows are allowed to move freely, they can wipe up the whole community. And that is the extent of Quarantine Act. And the law makes the president, that gives the president the power to make legislation, subsidiary legislation. And where the president has been unable to make this, the state governors are allowed to make legislation on how the cows will move. I always laugh. We always want to do new legislation. The law is there. You can use a state governor can use the Quarantine Act, request the president to make subsidiary legislation where the governor has the power to make legislation flowing from the Quarantine Act. It has subsidiary regulations where how the cows will be moved. There's nothing like free movement of cows. Cows, I'm sorry to say, and I join other people who said cows are not human beings because they are being regulated by the Quarantine Act. So maybe those senators who will argue had no opportunity of looking at the Quarantine Act to know whether such an act exists. But it is there. And the debate on trying to do anti-grazing prohibition, to me, is unnecessary because that act covers everything. How the cows can come, how the cows should be quarantined, how the cows should move. Because of the infectious disease, most likely some cows can bring like tuberculosis, like other diseases that we don't know. But here, cows are supposed to come from outside the country into Nigeria are to be quarantined. I think the law provides for a period of 30 days before they can be allowed to move. But nothing like that, because the legislation has been moribund. It is there in the laws of the Federation, but nobody has been able to activate and enforce. And no governor has been able to say, okay, the president has now made subsidiary legislation. Cows entering my state, I will use the Quarantine Act to make subsidiary legislation. They try to make a hype by saying ample grazing and all this other thing. That is the problem, the lack of information. As the issue of Kwara, you see...
Rivers and Kano. Number one, Kano
okay, Rivers,
a city with two
Rivers
kings. And Rivers, a land with two kings. Because all of this, the puppeteering that are puppeteering the strings is still because of the fact of Wiki and Fubara. So two lands with two kings. Rivers, Wiki and Fubara, Kano, two emirs. So the land of two kings. let's talk about those.
Okay, let me start with Rivers, my brother. Rivers, it's unfortunate that the judiciary should drag themselves into what ordinary is unfortunate situation. I think the best way Rivers could have been resolved is through political and amicable solution. I don't see where conflicting judgments are coming. Where conflicting judgment comes from the same state courts or coordinate jurisdiction, it becomes very difficult because the party who is affected can choose which one to obey and which one to reject. That is what is happening. A federal high court and a state high court have concurrent jurisdiction in terms of their judgment. No one is superior. But when it comes to, and that is the challenge, where they said the matter has gone to court of appeal, and once the decision on the court of appeal comes out, it will settle the matter. The matter is in court, that is why I did not comment on the merit of what is going on. When you go to Kano, Kano is a chieftaincy matter primarily. The only element there is that element of fundamental human rights. Chieftaincy matters are naturally dealt with the High Court of a state. The Federal High Court has no jurisdiction. But where a person complains of lack of encroachment on his fundamental rights, then two things exist. Tuku was very explicit. Chieftaincy goes to the state high court. Fundamental right, as it affects the emir, for instance, an emir is removed, is banished to move to another state and stay somewhere. You know, that is directly the constitution forbids such an archaic way of life. So, and again, another interesting aspect in Kano is that a repeat act of state law is very difficult. It's very, very difficult. If the State House or something may have the power to repeal an act, and that is where the problem may come. No matter how you may feel, issues of fundamental rights will exist, but the issue of repeal will be very difficult to handle because the law has been repealed, and you cannot force them to reverse the law. But unfortunately, I do not. In terms of the real constitutional matters relating to fundamental rights, yes, the federal government has, the federal high court has jurisdiction. But when it comes to pure chieftaincy matter, as to legality of the repeal and all the other ones, then you go to the state high court or perhaps industrial court because the emir is still a staff. In fact, he's even a staff of a local government. In some states, an emir or a chief is a staff of a local government, not even a staff of the federal government. And then the issue of chieftaincy is a matter that is completely on a residual list, so it's not even something the federal high court could think of coming into. But since the matters are also pending in court, I have restrained but the most difficult thing to understand, to point out, is that I saw on the papers, whether it's true or false, that the former emir of Gaya has accepted his fate. So where something is happened like that, and the others say, okay, I've accepted my fate, it becomes very difficult to understand why issues, because others are saying that the law has been repealed and I've accepted my fate. So it is a little difficult. But there's something another interesting. You know, you don't just take away acquired rights without compensation, but that is another ball game. It's another legal issue. If it's a civil servant that has statutory flavor, you know what to do. Nobody can just walk up one day and say, I'll terminate you if you are working in public service. But this is chieftaincy comes from a class that is very peculiar. Their tenure is not defined. Their tenure is for life. It's only the governor and the law establishing them that can determine that tenure. And here the law has been repealed. These are the challenges we have there.
Sure.
But all the same, this is not healthy development.
Sir, well, I would like
but honestly, I don't look at it
Okay, a number of issues. In Rivers, number one, the governor says that he's defending the Constitution by insisting on non-extension of the tenure of local councils, which pitches him against the Amewule-led faction of the House of Assembly, which claims to have extended the tenure of the embattled local government chairman because the governor did not arrange elections. But at the same time, the same governor has created caretaker committees. And his argument is that in 85% of the states, other governors have established caretaker committees in order to make sure that there is no vacuum. Is the governor of Rivers really defending the Constitution? And then secondly, you just refer to the National Industrial Court. You refer to the National Industrial Court in the matter in Kano. But I recall that Femi Falana and your brother Silk wrote an article a few days ago saying that the National Industrial Court has no jurisdiction where chieftaincy matters are involved. That the National Industrial Court can only inquire within the purview of the Constitution into issues of pensions, wages, salaries. He made that distinction. So I just need a clarification on that. And generally, since we are assessing rule of law.
If you look at it, generally, we call emir chief, but basically they are civil servant. If you see their letters of appointment, my father was one, and the letter of appointment, they were staff of my local government. Even though the chairman could respect my father, but in the letter of appointment, he was a staff of the local government. And where his appointment is terminated wrongly, from the letter I saw of my father, the only thing dealing with appointment, and recently I saw industrial court assuming jurisdiction where an emir or chief was removed, I think in Kaduna, without fair hearing, because they came on the premise that he was a staff of the local government, and by his letter of appointment, he was not given a fair hearing before he was removed. That was done last week by industrial court, and he was restored back to his office. That was in Kaduna State, if you look at it from that point. But if you look from the point which I think Leonard Sik is talking, this is a point where a whole chieftaincy act, a law has been repealed. If it is repealed, there's no others. Industrial court will have no jurisdiction. Federal High Court will have no jurisdiction, because what you'll be contesting will be the legality of the action of the Kano State House of Assembly in repealing that act. I think that is where he was talking. And in that, I totally agree with him, because here, the law itself that established the 5 emirates was repealed by House. So what you can only go to court to create validity is to contest whether the repeal was legal or illegal. And that will be only a state high court that will, in Kano, that will have jurisdiction.
Rivers.
Then coming to the issue of Rivers, caretaker ab initio has been ruled by the Supreme Court to be illegal. And it's just unfortunate that we are not prepared to enforce the law. I had expected that the Supreme Court, having clearly stated that caretaker committees are illegal, the appropriate thing would have been the federal government not to assist to commit an illegality. And I will go further, Ruben. If the Supreme Court has given judgment that caretaker committees are illegal, they are in violation of the Constitution, then why did the federal government release funds relating to caretaker committees to the states? Because federal government, in view of this judgment that have been subsisting, in respect to the Supreme Court, can hold back those funds until they do a proper election. Because we have to all take steps. Every individual should be able to take steps to enforce the judgment of the Supreme Court as a person or as a law enforcement agency. And the federal government, having known that caretaker committee in several judicial decisions have been, and governors are still going about and setting up caretaker committees as they wish, Can't we for once look at the judgment of the Supreme Court and say, look, this is the judgment of the Supreme Court. You have not done election. And I cannot release money to an illegal body. That can be done. And this issue of caretaker committees coming here and there will be moribund. So I don't know, because I've not heard in the circumstances the tenure of the local government elected chairman in the House or in Rivers, the circumstances the House or Assembly extended that tenure. If I see the law, whether they had power to extend the tenure of elected local government officials, I could comment more effectively on that. If they don't have the power, extending it doesn't give good signal. But if they have the power to extend for a period, then that extension, if it is done validly, ought to be the law. Let me put on the light.
But are you there? Looks like the screen is blank. Okay. We can see you now. I wanted to ask you. Hello? Hello, sir.
Yes, I'm hearing you.
Okay, I wanted to ask you to just comment generally on the rule of law and those areas where you think that this administration, the Tinubu administration, needs to pay more attention. Journalists in particular are saying, under the watch of President Tinubu, who is himself a major media entrepreneur, over 49 journalists have been either harassed, intimidated, or detained, not to talk of other aspects of justice administration. What would be your advice as a former chief law officer of the Federation?
My advice is that fair hearing and freedom of movement are cardinal and internal rights of persons that is donated by God. Where you feel somebody has committed an infraction and you feel that it is desirable to arrest him, the Constitution specifies that he should be charged to court within 24 to 48 hours. But detaining people endlessly actually violates the Constitution. That was one of the major problems I had, because I was given the charge to enforce the rule of law. And rule of law is such that if you follow the law, most people will look at it from the point of view they want to look at it. Some will look at it as you are protecting criminals. Some of them will look at it as you are following the rule of law. The Constitution is clear, and my position has been, no matter the amount of detention, police or other security can detain somebody, the person that will find the person guilty or not guilty is the court. And we made the Constitution, which is the organic law of this country. It took so serious that it defined how long somebody can be detained. And therefore, I felt that it is better to follow the Constitution. We cannot be seen in a country as ours at this stage, at this modern time, to be treating that provision with impunity. Because if you detain the person for 1 month, at the end of the day, you yourself who detained the person cannot adjudicate, cannot determine the guilt. So whether it's a journalist or not a journalist, you feel he has committed an infraction, arrest him and charge him to court. We have the laws, and the Constitution charge him to court within 24 hours if there's a court close by. But if it is not within 48 hours, I think the section is around the
Section 35.
Fundamental Human Rights.
Section 35.
And these are fundamental human rights, and people used to enjoy the fact that somebody has been detained forever. But this is, when I was applying it, I said, I cannot be selective. Whether you are a corrupt person, but charge you to court within 48 hours. The argument there is that when you go to court, the court will grant the person bail, and these are the sentiments that are counter to the Constitution. The Constitution was drafted, and no country will just sit down and see the Constitution being violated with impunity. And no matter the same feelings you may have, and Ruben, let me not lie to you, that was a sentiment. The same press that are now feeling the plank of what is happening, that the same place launch attack that I was supporting corrupt people. But will I say, when it's corrupt people, will I go and amend the constitution and say, let them be in prison endlessly for 1 year without taking them to court? What of the innocent one person? One innocent person that goes to be detained endlessly is an infraction that is not redeemable. Is an infraction before God also. And that is the reason that the window of detention was created by the Constitution itself, to say, do it not more than 48 hours. And I felt that a democratic system with a very modern president and with a modern society should follow that provision. We have courts all over. You can take the person to court and read the charges against you. And if you feel that your investigation is still in progress, the person is released on bail, can interfere with your investigation, you apply to the court. At least the person will be able to have charges against him within 48 hours. That has always been my position. I have not changed it when I was in office, and I will not change it now. That is the constitutional provision, and we ought to be bound by it and respect it, so that people can, that provision create deterrence. You know that if you commit an offense, there's nothing like I beg you, the court you face the music, you go and face the court. But why are you detaining somebody for so long? That means you are waiting for a beg you for what? Because at the end of the day, the detaining authority has no power to judge the person. At the end of the day, the detaining authority can only eventually get a conviction, or the accused person will get a discharge in a court of law. So I think we have come to a time that we should be realistic and respect that provision of the Constitution, because the provision deals with the life of individual. Let me take it in a more humorous way. With hunger and everything, a lot of people have disease. They are not feeling fine. Some are disease-induced, some are hunger disease-induced. If you go and detain him endlessly and he cannot cope, his energy level is not enough to sustain 48 hours, he dies there. You have a bigger problem. So I think we should be wise enough to do the right thing.
All right. Thank you. I'd just like you very quickly to touch on the fight against corruption. And some cases are already ongoing. I'd like your take on, very briefly, the Kogi situation, the Kogi State, former governor of Kogi State, and the attempt to bring in him for questioning by the FCC, and the protection he received from the current governor of the state, Usman Ododo. And I wish I could talk about the Kaduna State issue, and I was going to get your comments also on the ongoing Nnamdi Kano situation, talking about the rule of law. Just very quickly, as you summarize your thoughts this morning.
Well, you see, all over the world, Kogi State, the matter is pending in court. There is also a judgment of the High Court of Kogi, which says, yes, it did not stop EFCC from arraigning him, but the court of the High Court of Kogi gave the procedure. It said, go and file charges, and the court should issue summons against him. That is the decision of the High Court. The existing case, summons have to be served on him. If you have any other further charges, go and file them, and the court should serve him summons to appear. That is the position of law. Another position of law in Kogi State, which is something, the Federal High Court have a territorial jurisdiction in several cases, but have a limited jurisdiction in criminal matters. Section 45 of the Federal High Court Extraordinary has narrowed the jurisdiction of the territorial jurisdiction of the Federal High Court in criminal matters. I mean territorial jurisdiction. So that also is something that we have to look at. The man was governor of Kogi State. So I wonder, the Federal High Court in Kogi State. So if you're accusing him of breaching the trust of Kogi State, then the territorial jurisdiction is one of the ES prosecutors, Rotimi Jacobs. He even wrote in his book that the law is settled on the issue of territorial jurisdiction. There are 5 Supreme Court decisions that specify where you should charge the person, where the offense was committed. A governor of Kogi State must have committed the offense in Kogi State. He has stolen, if the allegation should be an allegation of stealing Kogi State. So if you go by what Rotimi Williams, which is EFCC #1 prosecutor, and the decided authorities, the issue of jurisdiction, territorial jurisdiction, will come in. Federal High Court have civil jurisdiction across the whole country. Section 45 of the Federal High Court Establishing Act, when it comes to criminal jurisdiction, offense must be tried where the offense is alleged. That is the position. I will not go further because the matter is pending. Because that thing was applied in J.C. Bori case where he was charged in Kaduna. And there are several other cases.
But sir, could there be, a conflict between territorial jurisdiction and subject matter jurisdiction?
Territorial jurisdiction cannot be a conflict. Territorial jurisdiction is that it's just for the purpose of criminal trial. Because if the offense is committed in Lagos and you are to charge the person in Lagos, or you brought him and charged him in Sokoto Federal High Court, does it make sense?
Okay.
That is the essence of the criminal jurisdiction in territorial matter. Ruben, you seem to be very knowledgeable in law. Go and read Section 48 of the Federal High Court Establishment Act. It talks of criminal jurisdiction, restricting and Supreme Courts are interpreted in 5 cases. All of them is that the offense must be tried where it occurred.
Okay.
All of them.
Thank you very much.
And Rotimi Jacob, around page 400 and something, said the law is reasonable settled. The offense has to be tried where the offense, or else it will be looked at as forum shopping. That is the position. I cannot go further because the matter is pending in court.
Well, on that note,
the other issue you wanted me
was on Nnamdi Kanu.
What is the other issue?
Was on Nnamdi Kanu, but we're out of time, sir. I'd asked you a question on the Nnamdi Kanu trial. Yes.
Nnamdi Kanu's case is terrorism. And I think they are talking of treason too. Is it treason?
Yes, treason.
Treason is not ordinary bearable. Treason is not ordinary bearable. Both anywhere in the world, it's not ordinary bearable. There's nowhere in the world that you will stand in trial for treason that is ordinary bearable. The chances of bail are very narrow.
All right.
Okay, thank you very much. On that note, we'd like to thank you very much for joining us on the morning show.